Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. I'm sparking revolution, it's a truth-telling tale.
Hey, everybody. Welcome to the Loud Little Ducky. We are going to go back to Owens V Echard quick. There might be maybe 5 at max videos left. And so we are going to go over Echard's reply to the motion for reconsideration in the appeals court. And if you remember correctly, the appeals court has already fix this thing. Put my lights up. Oh, damn it. Okay. Technical difficulties. Okay. So the appeals court has already denied this. Owens lost already. Now, David Gingras, Laura Owens' attorney, wanted a reconsideration on the appeal because he says they all are stupid on the law, to sum it up, basically. That he is the all-knowing law person out there. So, we already went over, this is really making me mad. We already went over David Gingras's brief. I feel like we did that. And if we haven't, well, I guess I'll make a video, but I'm pretty sure we did. But today we're going to go over the reply from Clayton Echard and his attorney at Woodnick, which is Mark. Okay. So let's bring this up on screen. Present. Share screen. We are going to go to that. Okay. I don't like that view. Let's do. We'll zoom that in. I'm just messing with things in the background. Remember, as you're coming in, to like and subscribe. I don't remind people often enough. Okay. So we're going to zoom in. Does that make it look better? Okay. Wish there was a way to. Let's just do it this way. Okay. So we have in the Court of Appeals of the State of Arizona, Division 2, Owens V Echard. And this Clayton is the respondent and Laura is the petitioner. The Maricopa County Superior Court case, response to appellant's motion for reconsideration. And Owens is the appellant, so they're responding. And it's Mark Reisinger who is doing the appeals work. All right. Introduction. Okay. So it says, on April 11th, 2025, appellant Laura Owens, Laura filed her motion for reconsideration. The motion, pursuant to Rule 22, Arizona Rules of Civil Appellate Procedure, RCAP. On April 15th, the court issued an order taking the motion under advisement and setting a deadline for appellee Clayton Echard Clayton to respond. Clayton interprets the order as inviting a response pursuant to RCAP 22D. So this is where Gingras had put a tweet out and he was like, oh, we just got good news from the appellate courts. Okay. That they were going to look to see what you argued. And then they were like, yep, this is stupid. All right. This is going to bug me. Okay. Laura's motion offers two arguments. One, the court's structural error analysis misstates Arizona law. Two, reversal is mandatory because the trial court failed to make the required statutory findings to support an award of fees under ARS 25324 or 25809. The preamble to Laura's motion states that reconsideration is not an appropriate vehicle to rehash arguments previously raised and rejected, and Laura will not re-raise the same legal argument this court has already considered. But that is mostly what she has done. Yeah. She's rehashing the same shit. In fact, arguments that were not previously raised cannot be made for the first time in a Rule 22 motion, which a lot of us talked about, that Gingras raised things in the reconsideration that he didn't even bring up in the original appeal. So he can't argue them now. A Rule 22 motion can allege error in the appellate decision, of course, but it cannot make new arguments that could have been offered in the trial court or the appellate briefs. If Laura's assertion is true and only new arguments are raised, then the court can stop reading after the first page. So many of us wish we did stop reading after the first page, but let's hear you out because we apparently never talk about Owen's side of things. Part of the motion on page 2 through 5. Excuse me. Alleges the court, oh my gosh, the court misinterpreted the law. Clayton disagrees and explains the law below. The remaining sections on pages 6 through 18 were alleged new arguments that were not raised or developed in the briefs, despite being available to Laura before the memorandum. Oh my gosh, my throat is clogging. Despite being available to Laura before the memorandum decision. Clayton briefly addresses these arguments, but categorically objects to the consideration of new arguments that were either never raised previously or were not properly developed in the trial court or appellate briefs. This court cannot condone the relentless reframing of arguments that were either already rejected, not raised below, or not properly developed until the current motion. See Polanco v. Indris, an appellate 2007 case out of Arizona. Undeveloped argument waived on appeal. Like any other litigant, Laura strategically decided which arguments to bring and which to abandon at each state of the proceeding. See memo. Noting significant portions of appellate argument relies on incorrect assertions about Rule 26. 14. Appeal does not meaningfully challenge 25-324 findings. When an appellant strategically devotes limited space in the opening brief to arguments lacking legal merit, they must accept the consequences of that decision. But they don't want to accept any consequences, Mark. Discussion. A court properly held that the structural error analysis is inappropriate and actually prejudiced must be shown to warrant reversal. Laura argues, just as she did in the briefs, that a judge considering extrajudicial or ex parte evidence is per se reversible error. Not even a manual says that. We agree that the rule that a trial judge must be impartial does not mean that a judge must recuse himself from a criminal case merely because he has heard unfavorable remarks about the defendant in the course of prior litigation. Emmanuel Supra at 469, citing Commonwealth v. Campbell, citing another case. One's from 1977, one's from 1974. Finding no prejudice when sentencing, judge already possessed accurate information. Accurate information about the defendant prior to the sentencing from involvement in other matters. 1986 case, vacating opinion of the Court of Appeals that reversal was required because of ex parte communications where no actual prejudice resulted. The motion relies on cases addressing the substantive analysis of a bias claim, not per se reversal. Laura argues that the court erred because the ruling relied upon an erroneous application of Arizona law and that, in fact, the cited authority requires reversal. Specifically, Laura alleges the court misstated the law when it cited State v. Emmanuel. Oh, Laura alleges everybody misstates the law because those two, Laura, best pro se defendant ever. Not. All right. Page 5. For context, the court declined to apply a structural error analysis given the record before us. The reason Laura argued so intently for a structural error analysis is apparent from the briefs and the motions. She can only obtain a reversal if the court adopts a standard that does not require showing actual prejudice. The court correctly declined to apply structural error analysis, but that did not end the court's inquiry because reversible bias could still arise outside of the structural error context. The ruling correctly cites a manual for the proposition that a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias. Separate from a structural error claim, Emmanuel was not a structural error case and does not discuss or apply that standard. So we cite cases that, once again, do not have anything to do with anything. Gingras is very well known for doing that, in my opinion. Next, the trial court cites to stagecoach trials or trails, specifically paragraph 21, for the proposition that a critical inquiry into a prejudicial bias analysis is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. This is precisely what Stagecoach states. Judicial rulings alone do not support a finding of bias or partiality without a showing of extrajudicial source of bias or deep-seated favoritism. Stagecoach trails, emphasis added. In fact, the entire paragraph in Stagecoach is a collection of nested citations from other cases articulating the general types of evidence and standards necessary to prove reversible bias, not per se reversible under structural error analysis. These cases do not support the idea that prejudice must be presumed. Yeah, we can't presume anything in courts. That's the thing. You can't assume, you can't presume, you can't speculate. You can't make up imaginary things, like, you just can't do these things. I mean, that's why sometimes bringing cases is like, that's great that that's what happened, and we know that's what happened, but can we prove that's what happened? And sometimes you just can't prove the things that happened, which sucks. Except in the most extreme circumstances, Town of Paradise Valley versus Laughlin, appellate 1992 from Arizona, prejudice will not be presumed, but must be evidenced from the record. But see Grant v. Arizona Pub, 1982, prejudice may be presumed when the trial court seems to have completely lost control of the proceedings and had made a mockery of the concept of a fair and impartial trial. Judge Glanville in the YSL trial. Huge example of that. Huge example. Ooh, no. Let's look at that. This light is getting hot. I don't like it. Okay. Let's see. It's on their Instagram page. Mm. Is it on? What is it under? Is it just like a normal post? '24th. Complete. Okay, that's that. 1 day to go. 1 day to go. If you follow Bianca, you might see it in their live from today. I don't know who Bianca is. Have they posted it to Twitter? Oh, wait. Here, we'll bring that up. Hold on. We will bring that up. I found it on Twitter. All right. So it's Rachel Mitchell speaking. Come on. Really? Okay. Yeah, I've got the spelling. I found it on Twitter. So let's bring that up. Dang. Okay. Actually, let's finish this and then we'll go to that because I don't want everything to be so clunky. So it's in a thing. All right. This court already addressed these arguments and found Laura failed to even properly argue prejudice, much less establish it to a extent that requires reversal. However, Owens does not argue prejudice. Owens does not challenge any of the presiding judge's rulings under appropriate standards for appellate review. The motion does not raise any valid basis to revisit the memorandum decision, and resolving the appeal on new grounds raised in Rule 22 motion would visit tremendous inequity on Clayton and his right to due process. It stinks I can't make too much commentary on this because it makes sense. We'll make commentary in a minute. B, the court did not find error in finding attorney's fees were appropriate under ARS 25324, 25809, 25415. Laura argues in her motion for reconsideration that Clayton's motion for leave to amend withdrew his request for fees under ARS 25809, and that because the parties spent no time litigating parenting time, the trial court never made the specific statutory finding. Clayton was not entitled to fees under ARS 25324. To the extent these arguments are raised now for the first time, they cannot be considered. And they cite a case, arguments raised for the first time, and a motion for reconsideration waived. Moreover, in so arguing, she misstates the record and relies on an inappropriate, unpublished decision, Kent v. Kent. In Kent, the trial court made no finding explaining the reason for its fee awards despite repeat and specific requests to do so. Conversely, in the case subjust, the trial court made over 2 full pages of findings explaining the reasons for its award under ARS 25324 and 25415. The court already decided that the trial court did not err and that the awards would be upheld even if the trial court did not cite the most correct authority. Citing another case, reviewing court may affirm trial court if legally correct for any reason. Laura further claims that Clayton cannot be awarded fees under ARS 25324 because the court never made the specific findings required after Laura's request requested findings of facts and conclusions of the law under Rule 82. Laura relies on State v. Torres, Arizona appellate from 1987, but her argument ignores the basis for the holding in the case. In Torres, this court found that ARS 12849 did not allow an award of attorney's fees to the state. Laura's misleading citation stops just short of key parts of the discussion. The very next sentence after her quotation reads, "If the legislator had intended to require a defendant in a paternity case to reimburse the state for reasonable expenses incurred in bringing the case, it could have so stated." The next paragraph explains further. It says, "It is apparent that if the complaining witness had retained a private attorney and had filed the case in her name, the facts would have justified the award of reasonable expenses incurred in prosecuting the action. However, the complaining witness instead availed herself of the county attorney's designated attorney services provided for all persons by Gila County without the requirement that that pay for any fees. Therefore, she had the proper means to litigate the paternity issue, and the attorney's fees award was improper. Historically, attorney's fees have not been awarded in the absence of a statute authorizing them. We conclude ARS 12849E does not permit an award of attorney's fees." Okay, so that was what happened in the Torres case. Torres finds the fee award would have been proper had the prevailing party incurred any, but she was represented by the state and incurred no fees. The reason the fees were not necessary to fully and properly present of the action was because there were no fees. The statute did not expressly enable the state to seek fees in such case, and this court declined to legislate the issue itself. Then it talks about City of Phoenix v. Butler. The courts do not rewrite statutes. We will not rewrite statutes to effectuate a meaning different than the one the legislature intended. Torres does not support Laura's argument in the way she asserts. The trial court also awarded Clayton attorney fees and costs pursuant to ARS 25415 because Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery. The court shall sanction a litigant for costs and reasonable attorney's fees. Where a false claim is knowingly presented or a court order compelling disclosure or discovery is violated. Because these conditions existed, the court properly held that the court made such findings, thus it was required to sanction Owens, and that Owens did not meaningfully challenge that finding. Then it says, Laura claims that Clayton never sought relief under ARS 25415, and therefore she never had any chance to explain her side. This is false. Oh my God, Owens said something false? Can you believe it? She would never. As this court notes, although 25415 does not require the filing of a separate motion, as previously noted, Echard requested relief under this statute. Specifically on March 11, 2024. Before Gingriss's time, he didn't know about it. Clayton filed a motion to compel Laura's compliance with Rule 49, Arizona Rules of Family Law Procedure, and to disclose, among other items, her purported Planned Parenthood records. On April 9th, 2024, the trial judge granted Clayton's motion to compel. Still, Laura did not comply, and the trial court found she presented a false claim and knowingly violated a court order compelling discovery such that an award is appropriate under ARS 25415. Fees under ARS 25415 were therefore mandatory and appropriate. Laura had notice opportunities to comply, and opportunities to be heard before relief was given. She cannot change, tact, and challenge the discretionary amount of an award now. Yeah, she also admits at trial she failed to hand over discovery. So once again, she still failed to comply with the motion to compel. Lastly, Laura now raises objections as to individual time entries. She alleges they were not related to any parenting time issues and should therefore have been categorically excluded. Any such argument not raised below is waived. Laura's objection to the China doll application appears at, and they give a thing, the objection disputes the fact of award, arguing inter alia that the court could not award fees because Laura invoked Rule 26 safe harbor and the fees were for tort-based counterclaims, etc. Okay. She argued generally that the hourly rates were not reasonable under ER 1.5, but did not object to any specific time entries as she does now. She argued that the fees were not necessary because Laura intended to let the case be dismissed and alleged Clayton's desire to use this case for purposes of publicity and his counsel's wish for personal revenge against Laura were actionable abuse of process. She did not object to specific time entries or develop an argument as to the fees being unnecessary or casually unrelated to her conduct, as she now attempts to do. See footnote 1. Regarding the time entries for consulting with entertainment lawyers challenged on pages 13 and 14 of the motion, Clayton's counsel learned that Laura once auditioned to be a contestant on The Bachelor. Oh, she did. And contacted the attorneys regarding producing her application materials for possible impeachment use, investigating potential sources of information, including prior statements of do we have to go to the next one? Of a party is especially appropriate when a party has not provided full and accurate disclosures, as occurred in this case. It is well within the trial court's discretion to award fees incurred for investigation relating to a party's missing, incomplete, edited, or inaccurate disclosures of information where credibility is at issue. And boy, is her credibility at issue. Mark for Clayton then says this argument has been waived. Then we get to the conclusion. The Court of Appeals correctly affirmed the trial court's ruling. Clayton's request that the court deny the motion for reconsideration and grant leave for Clayton to file a supplemental application for attorney's fees incurred in responding to do it. The court should also note that Laura did not timely file an objection to the application for attorney's fees and cost filed in this appeal on April 4th, 2025. See RCAP 21B4. We already read the footnote, and it's certificate of compliance and what all they have to do for it, and certificate of service. Like, look at the rules. Okay, so it can only contain 2,348 words, or I don't know how many, but it's within that. You have to use 14-point Times New Roman font. Is double space for permitted single space quotations and complies in all respects. So they are told what font they can use. They are told what size it needs to be, the amount of words it can be, and it can't go over that. All of that stuff. All right. So now let's remove this. All right. And let's bring up this Stop screen share. All right. Let's bring up. Okay, let's share screen. Okay. So Bianca Buono on Twitter shared Clayton Echard's case update. She said she meant to share this earlier, but I asked Maricopa County Attorney Rachel Mitchell for an update on her office investigation into Laura Owens following the Clayton Echard paternity case. And here is her response.
Point, I mean, we are still actively I'm at the point, I mean, we are still actively investigating it. What I will simply say is stay tuned. I'm at the point, I mean, we are still actively investigating it. What I will simply say is stay tuned. I'm at the point, I mean, we are still actively investigating it. What I will simply
Okay. So I was muted. Thank you. So Rachel Mitchell states that at this point, they're still investigating, and all that she can say is stay tuned. So Laura Owens is not out of the woods yet. So we'll see. We can only hope. Is she just saying that so people will leave her alone? I don't know. I don't know what they're actually doing in this case or what they're not doing. And then I was talking about my hair, that I was like letting it just air dry, and normally I just throw it up in a ponytail, but um I don't throw it in a ponytail on stream. I'm very self-conscious about myself in a ponytail on camera. But I'm self-conscious about myself on camera, period. But all right. So that is that. Now I want to go to Owen's Medium article. Yes, my feathers. I just am letting them dry. And I don't like when I put my hair up in a ponytail, like, because I have such a huge forehead. I feel like I look bald. Like, when I don't like myself in a ponytail. Like, I don't like it. Like, I don't like how I look anyways. All right. Okay. What is this? All right. So, how long is this stupid thing? Okay, it's not long. Thank goodness. All right. Interesting. All right. So, now we are going to go. We're going to share the screen for the Medium article. I do not know if she has changed it since then. I thought she had deleted it, but apparently it was buried. Thankfully, somebody helped me find it. Lauren Nighty helped me. Because she's a real one. Alrighty. Share screen. Okay. All right. Okay. So, her article. The court ordered him not to talk about me. No, the court did not order that. Nowhere did the court order that he was not allowed to talk to you. And she says he responded by launching a smear campaign. I'm sorry, who contacted the public? I believe you contacted the public. Why is there not a better option? Oh, no. No. I don't even know. What is this? Cancel. The update is that they are still investigating and to stay tuned. It was like a 7-second clip. All right. Okay, I want to, you know what? Where was he ordered? Is there a ruling on that? I guess we don't have a copy fully of. That's police reports. Let me go to documents. Let's see here. Because I don't know. Okay, but he was not ordered not to talk about you. He was ordered not to contact you. So, yeah. First Amendment. He has his First Amendment right to speak out. Like, we're having huge issues with people understanding First Amendment in Massachusetts. She does not understand the First Amendment. They cannot tell him that he cannot talk about her. He just cannot reach out to her. He can't send her a video. He cannot have somebody else on his behalf reach out to her. She's a liar. Liar. It's all she does. She wrote this 2 days ago. She says, I got 11 claps. Do not give her claps, people. Must be 11 people in her life. All right. On August 1st, 2023, I filed a paternity case against former Bachelor star Clayton Echard following a sexual encounter at his apartment on May 20th, 2023. The situation quickly escalated into something far darker and more unbelievable than I ever anticipated. Ma'am, everything you do has a dark cloud around it. On October 6, 2023, I sought and obtained an order of protection against Echard from the Maricopa County Superior Court after he sent a series of threatening text messages and posted false and harassing statements about me on social media, igniting a hate campaign that his followers carried out. He did not ignite a hate campaign. The order was clear, specific, and legally binding. All right, let's see. Let's see what it says. We know how she quotes. They're not always exact, but let's see. Defendant shall have no contact with plaintiff. Okay? He has not had any contact with you. And shall not cause others to contact plaintiff other than as outlined herein, which I'm guessing is his attorneys can contact her attorneys for court. He has not had others contact you to do anything. Nobody has done anything on behalf of Clayton Echard. Okay? So that's two things Clayton hasn't done yet. So far he hasn't violated. Defendant shall not communicate. He has not communicated or post untrue. Well, he's not posted anything that's untrue, so still not violated, or harassing comments regarding plaintiff online. He has not said anything harassing you. Included but not limited to on social media. Well, he has not communicated with you on social media. He has not posted any untrue statements on social media. And he has not said anything harassing on social media. And shall not cause others to communicate or post untrue or harassing comments. He has posted none of that, and he has not caused anybody to do anything. You and your actions have caused people to speak out. None of us are doing it on behalf of Clayton. Clayton did not tell any of us to do this. Your actions has us outraged, and we're going to talk about it. I hope charges are coming. Yet she's always retelling it. I don't think she thinks people will believe her eventually. I don't think that's the thing. I think she does this to convince herself. Because she knows she's not convincing anybody. Like what her few people she has in her life is like supporting her. I think she's just trying to I think she's trying to convince herself and trying to spin a narrative. But 11 clots is not going to get you there. You have ruined yourself, ma'am. Clayton did not do any of this to you. All right. And then she said 19 days later, on October 25th, 2023, when Echard fought the order at a contested hearing, the court doubled down. The Honorable John Duty was blunt, telling him, it's almost like you can summon a tsunami with your followers. That is something that can be added as reasons for my decision under the harassment statute. When was this said? You not only expressed your intent, but then I find that you followed through with it. You used the means that were available to you in order to, frankly, get her to stand down. I believe that it caused the plaintiff to feel seriously alarmed, annoyed, humiliated, and mentally distressed. It made her feel that way as a subjective matter, and that it would have caused a reasonable person to feel the same way under the circumstance. The court finds by a preponderance, not a preponderance, of the evidence that there is reasonable cause to believe that the defendant has committed an act of domestic violence within the last year. This message was unmistakable. Echard had crossed a clear line, but instead of retreating, he stepped on the gas. Are you fucking kidding me? Why do I not know that Judge Duty said this? Did he say it in his order that we don't have? Because we don't have a copy of that order. That's what I was looking for. She filed it, and then she said, what date did the court find that? On the 25th. Setting hearing date, motion. This just says approved. Like, he didn't say this in the hearing. We don't have a copy of the order. All we have is that it was approved, and the approval as order of thing. Wait, what is this one? I guess we may not have access to that. Like, this really pisses me off. I don't know. Let's see. Okay. Okay, let me see here. Videos. Looking at Snitchel Ninja's channel. Mm-mm. Let's see here. Oh, I do. I guess have I not watched that? I'm gonna have to watch that. I will put here. I'm going to copy the link. All right. Here is the link on Schnitzel Ninja's channel for that. All right. I don't know how to pin a comment either. I don't know if you have to do that on the YouTube end or what you have to do. I'm going to have to watch that again because if this is the same hearing, I've already seen it, but if it's the same hearing that she gets up and wants to, she shows up pregnant, because I believe I've seen it. She gets up and she's pregnant. I believe she's wearing a striped shirt that day. Another judge. She had she definitely had ex parte communications with Judge Duty. Because he even admits them and he's like, oh, he had like the Amber Heard moment where she's, oh, I'm not supposed to talk about that. Sir. And he didn't even know how technology worked. He wouldn't even let them show him evidence to disprove this liar. He needed to retire, but that's why this needs to be dealt with. And Judge Mata couldn't do any reversing or anything, and so they definitely should have tried to reverse this, but then they let too much time go by. So, oh my God, that stuff pisses me off if he fully said all that. Ugh. And this is why she has done what she has done, and she has continued to do it for the last 10 years, is because people like Duty had let her get away with this bullshit. Probably. Oh my God. He didn't do anything. I don't even think he watched anything. If he would have seen anything that Clayton posted or a video or anything, he would have been like, no, that's not something scary. But he didn't even look at any of the evidence. He just believed what she said with her fake ass picture that she said that Clayton created. And it was her sonogram and only he had it. Duty wouldn't even listen to anything else about that, even though it wasn't her sonogram. Yeah. He's like, oh, she looks pregnant. And wish somebody would have raised her shirt. Oh, that hearing itself pissed me off and showed me he shouldn't be on the bench. God, that pissed me off. And here she is gloating that that was an act of domestic violence. I don't know how that's an act of domestic violence, but okay. Like I bet there are plenty of women that wish this is the domestic violence they dealt with. They wish it was this. She says the message was unmistakable. Echard had crossed a clear line, but instead of retreating, he stepped on the gas. Echard launched a calculated media blitz, dismantling my reputation in direct defiance of the order. It's funny that the cops didn't seem to find that this was a violation. He understood something devastatingly simple. If he spoke loudly and often enough, no one would hear my voice over the noise. Ma'am, you've not shut up either. He shut up more than you did. You kept talking. Your attorney from Easter weekend of 2024 kept talking and is still yapping his mouth. Echard has said a few things, and then after the case, he said stuff, but everything has been you. Other people have stood up for Clayton, but he has done not a damn thing to you, woman. My voice would be, oh, God. She infuriates me. In January 2024, Echard gave an interview on the biofiles. He called my protective order against him fake, praised his little Reddit army of followers, and bragged, I'm going to tell everything everyone wants to know about the situation. He let the court case speak for itself. He didn't go out and say really anything. I think after the biofiles, he didn't really ever speak up until like about this case until like the day before the hearing when it was the three of them standing there. She projects. Doth protest too much. Directing his audience, he urged, if you go on Reddit, look up Justice for Clayton, you can find out all of her information. It's important her name gets out there. Yeah, but he didn't tell people. He didn't tell people your name. He just said it's out there. I don't even know if he said go look it up. He might have said if you look it up. Yeah, if you go and look it up. It's under this. You can find out all the information. I don't know if it's her information, but whatever. Determined to keep the pressure building, he insisted, I'm asking people to blow the story up. I'm looking for strengths in numbers, and declared, we've got to get this thing to blow up nationally. Yes, this story does need to be national because women like you give women a bad name. Men think that all women are crazy like you. That all of us are liars. I don't trust. This is why I don't believe all women, is because there's women out there like you. And it needs to be talked about because not enough people call women out and tell, and hold them accountable for lying. Everybody just looks at them as little poor victims. No. I warned my son about some of these girls out there and to be careful with them. I warned my daughter of her friends. They can be vindictive, manipulative, set you up. Since it's for Ron Owens, I don't know if they will. They might, but I don't know that they will. It would be nice if they were transparent. They would just show the receipts, but they don't. Desperate to legitimize his attacks, he cast himself as the victim and urged others to join him. If you're someone that has been victimized by her, please reach out to me because we are only going to overcome this in numbers. Why did he say that? Because he knew there had been other victims at this point. And two of them, thankfully, had come forward. One he knew pretty much right away. And then he found out about the other one. And then found out about others based on your deposition. When you're like, oh, this guy from like 10 years ago? On the Not Ashamed podcast, he revealed in the chaos he had unleashed boasting. The community of people that keeps uncovering and supporting me is tracking her every movement. And it's like, you brought this on yourself. Yeah, you did. He doesn't have to track you. He's not doing anything. But the world is watching, Owens, to make sure that you don't hurt another man and put them through this. We want you to get help, but we know you're not going to, and your family's not going to make you. He wanted to hunt me, humiliate, and destroy me. He wanted credit for it. Well, he kind of deserves it because nobody else stopped you before. Nobody else fought back. For a year and a half, the harassment has swallowed everything. My reputation, my safety, and at times my will to live. Oh, here we go. Echard has known this, and still he keeps taking the same approach while his army cheers him on. You know what most of us have done? Most of us have moved on. And your lawyer wants to get up there. Move this for a minute. Your lawyer wants to get up there and say, that's not the girl I know today. Maybe she did that stuff in the past, but she doesn't do that anything. Ever since I've known her, she just doesn't do that stuff anymore. But yet, you renewed your restraining order for Greg Gillespie. You filed another police report on Clayton Echard this year. You are continuing to fight on an appeal that you know you rightfully lost, on a case you rightfully lost. You know everything you've done is a lie. And you keep writing these Medium articles. Because what happens is people have stopped talking about you. People have made you irrelevant again. And because you don't like being irrelevant, you make moves. All of us are covering different things for the most part. Some are covering Justin Baldoni and Blake Lively. Some are covering the what the hells in Florida. I'm covering Karen Reed. And because we're not talking about you anymore, it hurts your feelings. So to say that all of us are continuing to harass you and talk about you, that's not true. That you're responding to us. We're not talking. We hadn't been talking about you. We talk about the court case. So, oh, she's not the same person. Yeah, you are. You're exactly that same person that you have been the last 10 years. And your lawyer is full of shit. Let's get back to this dumb article. It's almost over. Thankfully, it wasn't a long one. Taking the same approach while his army cheers him on. Okay. Despite the fact that I had no interaction with him after October 2023 and filed to dismiss this paternity case against him in December of 2023. How long after you miscarried? Or fake miscarried? I miscarried. An attempt he blocked. I'm sorry, nobody can block your miscarriage. Like, I know that's not what you meant, but you're supposed to be this amazing writer on the Medium, and saying he attempted to block your miscarriage. He attempted to block your dismissal and you to worm your way out of this, but no blocking of miscarriage happened. Echard betrayed me as the one who wouldn't leave him alone. Ma'am, over 500 messages? In an interview more than 7 months after my last contact with him, he called me a cockroach that just won't go away and a pest. Yeah, she did not inherit her mother's writing skills. She didn't get any redeeming qualities of her parents because she sucks at everything. She sucks on her podcast. She sucks at life advice. She sucks at TED Talks. She sucks at acting. She sucks at writing. And yeah, you know how you're like a cockroach, even though you're not personally contacting him anymore. By continuing the nonsense that you did in this case, is a pest that won't go away. Because you could just admit you're lying and go the F away. Nobody wants you here. And that doesn't mean nobody wants you on earth. That just means nobody wants you in their vicinity. Go back to your life. Yeah, she sucks at everything. And we know she can literally do that too, because TMI details for this case. Ugh. The mere act of defending myself, of telling my story and writing on Medium, became in his mind an unforgivable offense. If you keep pushing my buttons with these stupid articles, I'm one button away from being pushed, he warned. That means he's going to sue you for defamation, you dumbass. Because you keep defaming him. And you're knowingly lying. And a court has found that you're knowingly lying. So therefore, your story still, the way you said it happened is not true. And you keep saying a bunch of things that did not happen. He says his threats were calculated promises, each more sinister than the last, as he pledged. We have drained her of her money. Okay. Where is that quote from? Is that another quote from some podcast thing he did? Well, go to McDonald's. They will write you a check. They are always hiring. They need people for the drive-thru. They need people to cook the chicken nuggets and make the burgers. You can have money if you go work at McDonald's. He vowed to go full scorched earth on me, boasting he was getting a little fire under him, as if destruction was not just inevitable but deserved. Yes, it was deserved. And eventually, karma and your past catches up to you. Then, as if it was the most natural thought in the world, he said, I thought I should burn this person. If she says in anything that I see in a public document, if I see in any public document of her saying that Clayton's threatening to light her on fire or burn her with real flames and is going to set a house on fire or her on fire, if I see her claim that she thinks he's literally going to set her on fire, I'm going to lose my ever-loving mind. That I hope this is not what she is setting up. Because nobody in the listening to these things in full context would ever think that. But I can see her spinning it to that. She will need to go to jail for that. She needs, oh God, what happened? Okay. Ooh, I don't know. Was never pregnant. The whole thing was lied. Yeah, and a judge found that too. So, and you still have not proven to anybody that you were pregnant. So, like, we're still waiting on the proof. And like, we would be happy to look at the proof you have if you want to provide it. I mean, we're here in May 1st of 2025, and you've still not shown us anything about you being pregnant. Like, where's that Los Angeles sonogram, Owens, that you talked about? Like, that would just make everyone see. He viciously attacked my positive blood and urine HCG pregnancy hormone lab tests. If I was claiming I was pregnant after I had my positive HCG test, knowing I had a hysterectomy, I hope somebody would viciously attack my HCG test, including the one that he purchased and he made me take in front of him, baseless, asserting you could manipulate them, which she did. I know she did. Later, he told Reality Steve that they're known as pregnancy HCG tests for most people, but not her. I believe he said that in his deposition as well. Might have even said it on the stand. And it didn't stop there. You know how you can manipulate them? Horse urine. Labeling it a fabrication, cruelly dismissing one of the most painful experiences of my life. Painful how? Painful how? It wasn't physically painful because you didn't even notice it. You just noticed some blood. You weren't in that much pain. Emotionally, wasn't that big of a deal to you. And how many of these so-called things have you had? If you really had a miscarriage, which actually what is painful, and the process to be DNC'd, like that stuff is painful. It is a fabrication. It's a lie. It's horse shit. And you know all about that. Echard later falsely declared she makes up ARP claims. She makes up having ovarian cancer. Well, you have made those up, at least in this case. I have been ARPed. I've never had cancer. Well, then why did you tell Mike Maricini you did and send him documents about it? Thankfully, Nor claimed I did. You know, if he sues you for depositions or defamation, this is all going to come out. And it's not going to be a 2-hour hearing. You'll be able to get in all that shit. That laptop. All of it. But even this was not enough. On the Charlie Kirk show, he demanded, I want this referred to the DA because she should be prosecuted. Yeah, the judge thought so too. Kirk eagerly echoed his call, pledging to personally and publicly and privately encourage Maricopa County Attorney Rachel Mitchell to pursue charges weeks prior to Judge Mata's ruling. Well, Judge Mata agreed with that. She referred it herself. In another interview, he coldly stated she deserves to be behind bars. Hopefully she gets put away for years. Yeah. That would be the consequences of your own actions. Just one day before June 10th, 2024, evidentiary hearing, Echard posted an Instagram video. He stood at the center, flanked by Greg Gillespie and Michael Maricini, two men I also have active protective orders against. Echard painted the three as victims and declared, we are going to make sure she faces the consequences of her action. We are all here to see her referred to the DA for prosecution. Echard didn't just attack my presence. He sought to obliterate my past. Although the San Francisco Superior Court issued a Cleats domestic violence restraining order against Marachini in 2018 and again in 2020. Yeah, he didn't fight them, formally recognizing me as the victim. And you like those formal recognitions, don't you? Echard rewrote the truth. Who rewrote the truth? You rewrote the truth, insisting in reality she's the aggressor. Speaking about my TED Talk, oh God, we've already pointed out how stupid that thing was. A story recounted how a stranger on a plane slipped me a note during a flight with Marachini, recognizing that I was being abused. Echard dismissed it outright, although he had no knowledge of what the woman had witnessed, nor of what I endured during a relationship that ended in 2017, 6 years before he met me. All this getting snippy with you. That is it. That is it. My daughter. Okay, I guess my Wi-Fi is being stupid. Um, I don't know why my Wi-Fi is being stupid. But I have talked about how my daughter, instead of a stranger on an airplane, she has a stranger in a nail salon. And I was so mad at the nail salon because they are always like $5 more, $5 more. And we had went in there for a certain thing and I read their menu price, right? And I thought it was going to be a certain amount. And then she told me it was $100 and something dollars. And I was like, for acrylic? She's like, no, she got 2 colors and then she was doing dips. And I'm like, no, 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 that's not on. And I was mad with me on the menu where it says this to the nail lady. And this is going to piss me off. And so then when we leave, my daughter shows me this note where the lady that was sitting next to her getting her nails done, that it had her phone number on it and asked if she was okay. And so all that lady saw was me getting mad at the nail tech lady. Maybe she thought I yelled and screamed at my daughter or something. And she was making sure that my daughter was okay. Because she's with this crazy mom or whatever. And it made me laugh. And so I was thankful, it's good to have those people out there. If you see something, say something, let somebody know that there's somebody in your corner. But I was like, yeah, I'm such an abusive. Oh my gosh, this is aggravating me. That, I take my daughter to go get, such an abusive mom. I take my daughter to go get her nails. 2017 before he met me. Echard demanded the TED Talk take my speech down, saying why her TED Talk is still up baffles me. Take it down. The whole thing is based on a lie. You're letting a liar play the victim card. Shame on you. Yeah. Many of us have tried to get them to take that down. On June 18, 2024, Judge Matta handed in legal fees, despite the fact that he had incurred no legal fees at the time. I moved to dismiss the paternity case in December 2023 after I miscarried. The case is currently being appealed. Well, time. And so I don't even think that there's going to be any department on April 21st, 2025 to report Echard's repeated flagrant violation. There is probable cause that a crime and why is it too late if you just filed it? For more than a year, Echard has made a mockery of the law. A man explicitly ordered not to utter my name. No, that is not in the order of protection. Nobody said you cannot say her. Who instead shouted it from every platform he could find. A man instructed to cease his harassment, yet broadcast his threats to hundreds of thousands, turning strangers into vigilante information and hate. Man, we're reading court documents that you say that are from your mouth or from your own words. How do we have misinformation? Like we've read it or listened to it with our own eyes and ears. A man in peace who instead built an army intent. He did not build an army. He did not build anything. Your actions built an army against you on ensuring I'd never find it. Reflecting now, I can't help but wonder if I had reported him at the very beginning when he first defied the order of protection, would things have turned out differently? No, because he didn't do anything. Instead, I stayed silent and he kept speaking. Every threat, every lie, every rally. He said it himself. Okay. She's ridiculous. I don't know if this whole thing went mute afterwards, but we're going to shut it down because my Wi-Fi has been stupid. And I will see you guys later.